22 days to the 2024 presidential and parliamentary polls. Hashtag Stop Galamsey now still on. Good afternoon and welcome to the Midday News. The Midday News is live from our studios here at Kokomlemle's Joy 99.7 FM. We are live on Hits 103.9 FM, Love 99.5 FM in Kumasi, myjoyonline.com, live in all 16 regions. We are live on X Spaces, on Facebook. The Midday News is supported by Petrol Soul, Platinum Energy, Energizing Dreams. This afternoon, lawyers split over Supreme Court's decision declaring Speaker's ruling on vacant seats unconstitutional as escaping dissent of Justice Amadou Tanko ignites fierce debate on the judgment of the Supreme Court.
I feel absolutely vindicated, and I feel so even with a lot of humility. The person has switched camp while this eighth parliament is still running. So the seat is gone. They forfeit the seat.
We'll walk you through the reasons behind the majority and minority decisions of the Apex Court. Also, there is no order saying the 4 MPs must be allowed back in Parliament or recognized. That's the initial reaction of the Speaker's lawyer, Fadio Sori, to the detailed reasoning of the Apex Court.
After the Supreme Court has made a declaration in the exercise of its original jurisdiction, it is required to, quote, make such orders and give such directions as it may consider appropriate for giving effect to the declaration so made.
But that's being challenged.
Notwithstanding the lack of orders, the 4 members of Parliament are to keep their seats. It doesn't do much damage in practice.
Also in this package, expired rice scandal deepens as whistleblower Samuel Okujeto Bawku alleges high-level complicity within Education Ministry and questions credibility of internal investigations.
The FDA Investigation Committee spoke to Reverend John Intim Fojo, the Deputy Minister of Education, on this matter. Heavy political pressure brought to bear that this rice should be distributed came from the Ministry of Education. Let me drop that hint today.
We'll get to hear from the Education Ministry on this. Also, violent clashes continue in the Upper East regional town of Bawku, with at least 3 people killed this week and several houses set ablaze despite a 12-hour curfew in the area.
For Bawku, ever since the resurgence happened, a lot of the schools and other businesses don't open. People naturally don't leave their homes because of the shootings and all that.
And their sports.
And the Black Stars could save their AFCON 2025 qualifying campaign with a win today against Angola.
And it's a Friday. We'll take you to the funny side of the election campaign trail.
Statue. Normal kosi statue.
Na misrebusa say Ghana card etimi meyenya car ebetima meyenya car free.
That and more coming up in this afternoon's edition of the Midday News. I am Emefa Apawu. Please do stay on for details. This is your home of independent, fearless and credible journalism. Let's dig in now. And this afternoon, legal opinions are divided on the Supreme Court's judgment that declared the Speaker of Parliament's decision on the 4 vacant seats as unconstitutional. The Apex Court yesterday provided a detailed explanation for its decision to uphold the suit brought by Majority Leader Alexander Afenyomarkin. According to the Apex Court, Member of Parliament is deemed to have vacated their seat if they change their political affiliation and continue to serve in Parliament under a new party identity. Member of the panel of judges which decided the Afenyomarkin case on the interpretation of Article 97(1)(g) and (h), Justice Amadou Tanko has cut through the judgment of his colleagues, describing it as an aberration of the known rules of the Apex Court. While a member of our legal affairs desk, Kweku Asante, joins me in studio. She's been trying to unpack the reasoning of the court in that 109-page document. Kweku, first, let's start with the reason provided by the majority group.
So the majority group was written by Yauda Kwasari, who wrote the lead opinion. He says, in the result, we hold that upon a true and proper interpretation of Article 97(1)(g), the legal elements of what provision can be formulated as follows. 1. For an MP to be said to have vacated his seat, that MP must have left the party under which he was elected to join another party or become independent and seek to remain in Parliament under their new political status. Similarly, with regards to H, the proper formulation should be an independent MP must vacate his seat if he joins a political party in Parliament and seeks to remain in Parliament under this new political status. It continues to cite examples of Gladys and Soa, the Kintampo MP who sought re-election in 1996 on the NDC ticket, William Akoto, who served as the NPP MP for New Abrim between 2001 to 2004, and then sought to run as an independent candidate in 2004. Some of the arguments that the AG canvassed in court.
Well, there's also dissenting opinion, including Justice Amadou Tanko's opinion that the court may have acted unconstitutionally.
Yes, according to Amadou Tanko, and in fact, he starts with this blistering opinion. He says, I do not hasten to proclaim that I have apprehended with despair the majority's conclusion in this suit, but I state with utmost deference to the Honorable Chief Justice and the rest of my brethren in this majority, not only do I fundamentally disagree with their conclusion, I, with all due respect, also find their decision an aberration to the established and accepted judicial position of this court, with which, with profound respect, I hope in no distant future, the resultant usurpation of the constitutional prerogative of the High Court incidental to the majority decision will be reversed. And he goes on to state his view that if you look at Article 132, that gives the power to the High Court to actually stay proceedings and refer matters to the High Court. He says that this case must first have started from the High Court, and if there was a matter for constitutional interpretation, same would have been referred to the Supreme Court. I quote again, the present dispute, which invites the court to determine whether the seats of the members of parliament affected by the first defendant pronouncement, that the speaker, have become vacant, is vested in the High Court and not in this court. By assuming jurisdiction in this court, rather usurps the special and exclusive jurisdiction of the High Court on the issue, a situation which in itself is per incuriam the 1992 Constitution and potentially unconstitutional.
Well, stay with me, Kweku, because there's a lot of legal debate surrounding this particular reasoning of the Supreme Court on this matter. First, let's hear from private legal practitioner Kofi Bentel. He's happy with the decision of the court.
I feel absolutely vindicated, and I feel so even with a lot of humility. Every parliament has a life. It has a start, it has an end. What was the intention of the framers? Was it their intention that if somebody wanted to do something in the next parliament, things should disrupt this present parliament? That couldn't have been so. It cannot be that an action in this parliament, which takes effect in the next parliament, should be allowed to disrupt this parliament. And that's exactly what the Supreme Court justices came to. You have one parliament. The people who are filed to be in the next parliament, in fact, to be elected to the next parliament, are not saying themselves that they've left their party. They are continuing to work with their party till the end of the term of this parliament. It has become necessary for them to file because this is the only time they can file to stand election for the next parliament. And they have exercised their freedom of association to decide that they are coming back to parliament or standing election under a different political party color or as independent. That in no way affects this parliament. And we must know that they may not even win the election. So we are dealing with a moot situation, a situation which is supposed to happen in future. And in our parliament, in our Supreme Court, issues of mootness do not affect substantive issues that are happening today.
Well, we'll get to also hear the details of what the interpretation the lawyer or the speaker's lawyer is given to this particular issue. But another lawyer, Martin Pebu, says the court erred in granting the wishes of the applicant.
It's going to create a lot of double standards. What are you saying? If you want to see the double standards and understand very well in Parliament, the decision is saying there's no break in allegiance. You just look at it this way if you want to understand it more practically. So after your marching today, majority leader files his papers that he, in these 2024 elections, he wants to go to Parliament next in the 9th Parliament on the ticket of the NDC. And you say he can go to President Kufuor to hold any more discussions as majority leader or even as an MPP MP. Atuforsen files that he wants to be MPP in January 2025. So that's in the 9th Parliament. And you think John Mahama will open his doors to meet Atuforsen? No. What are you talking about? And that
Well, we've been hearing from the Speaker's lawyer, like I've been telling you, that he says that there's no order given by the Supreme Court as it's supposed to be. And so the 4 MPs have not been told to actually vacate their seat. They can go back to Parliament. This is generating a lot of talk. Let me bring in the Attorney General, Godfrey Adame, at least. He's joining us on the line. I also have on the line Kweku Ansah-Sareh. He's a former director of the Ghana School of Law. Thank you so much, gentlemen, for joining us. But let's hear what exactly Thaddeus Story has been writing on his Facebook page. Kweku, what does it say?
He says, in their judgment, the majority decisions, both Dakon and Asiedu, only expressed their disagreements with the conclusion reached by the Speaker in their response to the leader's statement. Their final orders never pronounced that the Speaker's response to the leader's statements are null and void and of no effect. In fact, he says, the only words order, however, were that the only grant of relief, one of the plaintiff reliefs, none of these reliefs is to declare the Speaker's response to the leader's statement as null and void. And now let us remember that the Supreme Court has made a declaration in the exercise of its original jurisdiction and is required under the provisions of Article 2, Clause 2 to say, quote, make such orders and give such directions as it may consider appropriate for giving effect. Thaddeus Story says the court did not make any direct order at the Speaker of Parliament for him to comply with.
Okay, well, Godfrey Adame, we are grateful for your time here on the Midday News. I think I'd like to start with you, really, on this particular matter. Thaddeus Story has been saying that, of course, these 4 MPs can go back to Parliament because there was no direct order from the Apex Court on this particular matter. What are your views? Did we lose Godfrey Adame on the line? Well, I still have Mr. Ansah-Sareh also on the line. You've been waiting to read the detailed reasoning of the court on this particular decision they took that day. What exactly are your views so far? Hello, Mr. Ansah-Sareh.
Yeah, thank you very much. Good afternoon to you. My view is that the majority did not make any consequential order. That is one. Number 2, the whole judgment itself is unconstitutional. It can be described as an attempt by the Supreme Court, by the majority, to rewrite provisions of the Constitution, which is not within their judicial authority. And therefore, to that extent, it renders their verdict unconstitutional. Number 3, as Bawku Amadou, DSC, rightly summarized, the court did not have the jurisdiction in the first. Number 4, now looking at the ruling, the various opinions, the analysis, one could find or feel within him a very bold attempt at struggling to find something to tell the nation, but struggled as they did, the majority could find nothing on which to write free. So as far as I'm concerned, this whole exercise has been not only needless, but has caused financial loss to the state. The NPP caucus must collectively bear responsibility for this. Martin Pebu just stated that he sees a double standard. I associate myself with the sentiments. The NPP expelled Alan Chemantin or Hininto and others based on an identical provision. Indeed, Article 3, Clause 9, Sub-Clause 1 of the MPP Constitution is in identical language with Article 97(1)G.
I bet then that you may be siding with Justice Tanko on this decision being an aberration to the established.
100%.
Okay, let me just bring in the Attorney General also on this. Please stay with me, Mr. Ansah-Sareh. So, Mr. Attorney General, I was asking you earlier, at least with the post that we've seen as his initial reaction, that's the Speaker's lawyer, Thaddeus Story. He concludes by saying that there is no order saying that the MPs must be allowed in Parliament or order directing that Parliament recognizes the said MPs as earlier ordered by the court. Really, where do you stand on this? Was there actually an order by the Apex Court?
I would say, why not? And I wonder why we do this ourselves in this case. When the court has spoken in such plain and emphatic terms, indicated that the relief sought.
Mr. Attorney General, you'd have to speak up. Unfortunately, we can hear you properly.
All right, I'm sorry. Good afternoon to you. I wonder why we do this to ourselves. I mean, when the court has spoken in such plain and emphatic terms, what does that have to do? They have to give effect to the others. There were specific relief sought by a party and to the matter, and those reliefs were upheld by the court. If you look at page 36 of the judgment of the majority, that is the one authored by Justice Dakwasari, he made it quite clear that in light of all the preceding discussions, this court determines that the plaintiff's suit succeeds. And then he proceeds to say, in the result, this court grants the plaintiff the reliefs 1A, B, and C, and makes the following further order. An order declaring the interpretation placed on Article 97, Clause 1, paragraphs J and H as inconsistent with the true meaning and import of Article 97, Clause 1, paragraphs J and H of the Constitution. So clearly, the orders were made. And so we really have to look at the relief sought by the plaintiffs. The plaintiff's relief, 1, which was granted in its entirety, was in these terms: a declaration that upon the true and proper interpretation of the 1992 Constitution, the light of Articles 2, 1, and all the other provisions that he states. A final nomination of Honorable Andrew Esama Amwako, the current independent member of Parliament for Fomna constituency in the Ashanti region, with the Electoral Commission to contest the Fomna parliamentary seat on the ticket of the MPP in the next or ninth Parliament of the Republic of Ghana, does not amount to vacation of his seat as a member of Parliament in the current 8th Parliament of the Republic of Ghana as an independent party to join the party. Then he repeats the same for Honorable Cynthia Morrison and Honorable Kojo Asante. So at least in respect of these three members of Parliament, 3 distinct orders were made by the Supreme Court to the effect that the change of their political, or the anticipated change of their political identity for the 9th Parliament or the elections which will occur in December 2024 does not amount to a vacation of their seat. What does it mean? It means that they have not vacated their seat and they still hold on to their seats as members of Parliament. And that is quite clear. I mean, I think that we must stop this unnecessary resort to some ill-founded or artificial technicality. This clear artificial technicality, it doesn't arise at all.
Okay, so you
and if you look at Article 2, Clause 1 of the Constitution, based on which the Supreme Court made these orders, it says the court is the one vested with the sole and exclusive jurisdiction to interpret the Constitution and, of course, declare any act or omission on the part of a person as unconstitutional, and that the Supreme Court shall, for purpose of declaration, make such orders and give such declaration. And such a declaration has been made. Such orders have been made by the court clearly.
So you insist that the Apex Court gave effect to its orders, but is it executable? Is the question?
Why not? I mean, so if the court makes an order that A, B, or C persons have not vacated their seats, what does it mean? Does it not mean that they are still members of Parliament? Yes, they are still members of Parliament, and that is the whole import, the hope of the exercise that are taken by the Supreme Court. So I think that we must stop this unnecessary attempt to resort to some artificial technicality and say that there has not been order made by the court. I mean, it's there in plain black and white.
So it's executable, but who is vested with the powers to execute this? As you're saying, you say it's executable. Who is supposed to do that?
So after the Supreme Court has stated that ex-member of Parliament is still an MP and has not vacated his seat, what does the person have to do? The person has to just walk into Parliament and go and sit and take his seat. And if there's an attempt to prevent that, that will then amount to a violation of the Supreme Court ruling. And that will have the consequences set out in Article 2, Clauses 3, 4, and 5.
Well, what would you say briefly? I'm sure that these are matters that we'll get into details of. But what would you say to Justice Tanko's dissent that this is actually an aberration to the established and accepted judicial position of the court? And for him, in the near distant future, it may be overturned.
Well, it's up to him. That's his thinking. And indeed, that is why this decision clearly reflects the fact that all the allegations made by persons about the so-called lack of independence of our judges is totally wrong. Day in, day out, our court, the Supreme Court of Ghana, clearly indicates that there is total judicial independence in the Republic. And this decision is the current or is the latest manifestation of such a situation. And it exposes the falsity of allegations made by people like Mr. Ansari that the courts are predictable and that the courts do the bidding of the executive. It tells you that our judges have clear independence of thinking. They are bowsprit and they can take any view that they wish to take. But of course, I would also comment on Justice Tanko's words and say that clearly they are wrong because he, as far as I'm concerned, his reasoning was faulty. His reasoning was just based on a very narrow and simplistic view of the Constitution.
Really?
Yes, because he failed to even answer the fundamental question whether an issue had arisen in the matter or an issue had arisen in the circumstances of the case.
How is it faulty? How is it faulty when he says, just a minute. You said it's faulty. I want to find out. He's talking about the constitutional prerogative of the High Court.
I'm explaining to you why I think the reasoning was faulty. And I'm saying that he failed to answer the fundamental question whether an issue requiring the interpretation of the Supreme Court had arisen for the circumstances of the matter. The only basis on which the court may invoke its interpretive jurisdiction is when an issue requiring interpretation of the Supreme Court had arisen. So he failed to determine that clearly from the facts before the court or from the words of Article 97, Clause 1, G, and H, it required interpretation.
Okay.
All he resorted to was to refer to Article 99 and say that the High Court had been given jurisdiction to declare a vacancy or to determine matters bordering on vacancy. But I make the point that it still does not oust the Supreme Court's jurisdiction to interpret the Constitution at all. Even in the case of fundamental human rights, where the court has been given, the High Court, has been given clear power to enforce fundamental human rights.
Okay.
If a matter bordering on interpretation of a provision in the fundamental human rights chapter of the Constitution has arisen, it's still the duty of the Supreme Court to interpret. And we have seen that not today. We saw that in 2007 when Nana Ejayam Pofu took a matter bordering on the fundamental human rights to the Supreme Court.
Okay.
And the Supreme Court asserted its jurisdiction in the matter. It was a judgment by Sofia Kufu, JAC, as she then was, if I remember. And the Supreme Court made it clear that, yes, notwithstanding the fact that the matter bordered on fundamental human rights, insofar as it related to an interpretation of a provision of the Constitution, it is still the exclusive preserve of the Supreme Court to do so.
Okay, so his opinion has been shared. Yours is also being shared. Unfortunately, we can't go any further on this particular matter. I'll just give the final words to Mr. Ansari on this. Briefly on this, we have to really wrap up. Mr. Ansari, so you've been hearing the Attorney General also on this matter, but on the issue about whether the 4 MPs would have to go to Parliament or not, and whether the Supreme Court actually gave orders, what are your views on that?
They are not going anywhere. The Speaker's communication is enough to keep them home. Now, let me take this opportunity to remind the Honorable Attorney General that the majority never ever made any order. No order whatsoever. Now, in any case, if the Attorney General will agree with me, which I believe you, the majority was quick to point out that there was no course of action in the first place.
Okay.
If there was no reasonable course of action, how could the same majority make consequential orders? Indeed, they did not even bother to refer to Article 2, Clause 2,
okay,
which will give them the power to make the consequential orders that the Attorney General is alluding to. They don't exist.
My apologies, Mr. Sassari. We'll have to leave it here for now. Subsequently, we'll delve deeper into this particular matter. Let me do some other stories before we go for sport. And the whistleblower in the expired rice scandal, Samuel Okujeto Ablakwa, insists the Education Ministry cannot be trusted to investigate the allegations as senior officials they are complicit in the matter. Mr. Ablakwa, who has been on a campaign since Wednesday to get individuals involved prosecuted, disclosed that Ghanaian-owned company Laments Investments Africa Limited imported 22,000 bags of rice in 2022 and repackaged it and distributed it after expiry to several senior high schools in February this year. According to him, several schools in Greater Accra received the expired rice and may be at risk of serious health implications, including cancers.
The release of the rice, the various schools, those who signed for them, the various headmasters who signed. So this is a confirmation, and those who received it have signed. This is for St. Monica SHS, Mampong. Received 1st February 2024. 520 bags of the 50 kg Moshosho rice repackaged.
And we've been hearing from the Education Ministry's PRO, Kwesi Kwarteng. He says the repackaging was done on the blind side of the ministry, but a full-blown investigation has commenced into the matter, and all corporates involved will not be spared.
That we take these allegations very seriously, and even based on that, we have immediately commenced a full investigation into it. As of now, we have reached out to these agencies that are responsible for the supply and distribution of food to senior high schools, particularly with regards to buffer stock, and we are jointly looking into the concerns or the matters that has been raised. Assuming the concerns that has been raised are valid, then.
However, Mr. Ablakwa does not trust the ministry to do a clean job, insisting that senior officials there knew about the repackaging and did nothing about it.
The FDA investigation committee spoke to Reverend John Intim Fojo, the Deputy Minister of Education, on this matter. So why are they pretending that I have brought this to their attention? That is why I insist that we need an independent, impartial investigation.
So this
the Minister of Education is complicit.
Brought to the attention of the Deputy Minister in January.
In January.
But the rice was distributed in February.
In February. And look, the heavy political pressure brought to bear that this rice should be distributed came from the Ministry of Education. Let me drop that hint today.
Okay.
And that's Noftong MP Samuel Okujeto Ablakwa there. Fentuo Tahiru Fentuo has sports. What's up?
Yes, Emefa, the Black Stars of Ghana, they could save their AFCON 2025 hopes with a win today against Angola. That game is at 7 p.m. And that's because Niger thrashed Sudan 4-0 in Togo last night to deny Kwesi Appiah's team an automatic qualification slot. Daniel Sosa, whose mother is Ghanaian, produced a man of the match performance with a hat-trick to keep Ghana's chances alive. That result means a win against Angola tonight will breathe fresh life back into Ghana's dying campaign, and head coach Otto wants to take full advantage.
It's going to be difficult. It's an away game. It's going to be very, very tight. I know, but I think mentally the boys are ready. Yeah, looking forward for that game. Yeah, it's time for the first victory in this competition, and it's a great chance to keep the chance alive.
That's Otuado there. We'll have more on game plan at 1:15 p.m. Up to you.
Can't wait for that. And with just 22 days to the general elections, political campaigns are heating up, but not without their lighter moments. This week, my colleague Collins Frimpong has compiled some of the most entertaining highlights on the campaign show.
Political campaigns are in full swing, bringing their share of humor and drama, from fiery jabs to the inevitable statue unveilings.
And it's a statue. Yakoha, normal kosi statue. Nipa unyem free abemu. Also free abemu na and krofokai wejuma pa.
Can there really be a fun side without Mahama and Baumia trading their signature jabs?
Osono enye ne dabre eni krum. Osono ne dabre ye kwayemu. Nipa dabre ni krum. Enye osono. Enti emre na so.
Sampinyi dada na yeku. Onu di obedi o mampenyi pe edi etuma no a obeti me di o mampenyi fie 9 pe onko election bio me de mami anyame ado metime di o mampenyi fie 8.
Well, self-proclaimed nation's prophet Ebenezer Adakwa Yadom entered the chat.
Na misrabu sase Ghana card etimi me yenya ka ebetima me yenya ka free because koso wo manimu a mementi ase.
And with just weeks to go, the campaign trail promises even more twists, turns, and unforgettable moments. Collins Frimpong's report for Joy News.
Now, and just before we wrap up, the Upper East regional town of Bawku remains engulfed in chaos as violent clashes continue to escalate, leaving at least 3 people dead this week despite a 12-hour curfew imposed to curb the unrest. We have more in this.
What I'm learning is that the incident today, but 2 days ago. Yeah, but I'm gathering more information as to how it all happened. Yeah, for Bawku, ever since the resurgence happened, a lot of the schools and other businesses don't open. People naturally don't leave their homes because of the shootings and all that. So it's kind of normal in Bawku for schools to for schools to be shut, to not open. Yeah.
Well, and that's our regional correspondent that giving us update on the situation. They're taking us out of the midday news here on Joy 99.7 FM on Hits. I'll hand you over to Doreen of You for entertainment news. Living Word with Pastor Mensa Otabil is up next. I am Emefa Apawu. Have a good afternoon.